is a certificate of need? It's not like your ordinary license. A traditional license looks like a license to be a doctor, and in order to get it, you have to go through certain training, you have to get certain accreditation, you have to go to school, you have to maybe apprentice for a while. But certificate of need programs are different because they have nothing to do with whether you're qualified. The only thing a certificate of need program purports to do is to decide whether a new business is needed. So how do you get a certificate of need? Well, you apply, you pay the fee, and again, you have to prove to the government that your business is needed. And that's bad enough as it is. Even the best entrepreneurs cannot predict with any level of certainty that their business is needed, but that's what makes America great, is that we allow people to try. We give them the opportunity to invest their own time and resources and to bravely experiment and see if their business is needed. But certificate of need programs are sometimes called competitors' veto programs because the way that the government evaluates need is by asking the incumbent businesses whether they think a new business is needed. In fact, all the existing businesses are invited to show up at the applicant's hearing and engage in essentially what is a full-blown trial where they can testify that the existing businesses are perfectly capable of serving all the existing demand, and in fact, no new company is needed. But of course, there's an inherent conflict of interest there. You can see how an incumbent business has an incentive to say that there isn't any new demand and to keep that demand for itself. In what industries do certificate of need programs exist? Very often we find them in the transportation industry, in the medical industry, and sometimes they apply to utilities, sometimes schools, and contracting. How did certificate of need laws originate? Well, it depends on the industry. When it comes to transportation, they are a relic of the late 19th century, where they were originally invented to govern railroads. And the thought was that people wouldn't invest in railroads unless they had some sort of protection for their investment. Now, that economic theory has been entirely debunked. And not only that, but certificate of need laws are very often applied to industries and entrepreneurs where it takes very little capital to get into that industry. So we see them as applied to moving companies, taxi companies, limousine companies, businesses that really should present a very easy opportunity for somebody to enter the industry and start a new business. When it comes to the medical industry, certificate of need programs have a totally different history. They were actually invented in the 1970s, and it was thought that medical providers were over-investing in expensive equipment, and then they would charge customers overinflated prices and recommend services that weren't really needed in order to recoup those costs. Supported by the hospital industry, certificate of need laws gained steam, and eventually they were even supported by the federal government, which passed a law tying public funds to the existence of certificate of need schemes. But just years later, the federal government realized that certificate of need programs were doing exactly the opposite of their intended purpose. They were driving up costs, they were leading to shortages of medical equipment, and quality was going down, and that's because of the anti-competitive effect of these laws. And so it repealed the incentive and untied the provision of federal funds to the existence of con laws. However, because con laws are so popular with existing providers, they stay on the books. And it's not just harmful to consumers, it's small entrepreneurs. It's people like Ursula Newell Davis in Louisiana who wanted to start a respite business for special needs families. That is, she's a social worker, and she found in her experience that very often families lacked care, and parents who worked unusual hours were forced to leave their special needs kids at home unattended. And so she wanted to start a business to give these kids care and to teach them life skills so that they would live a thriving existence. But when she applied for a license under Louisiana's version of a certificate of need program, they denied her in a 2-page form letter. Under their estimation, there were already enough businesses in the state, and so they weren't going to give her the opportunity to start up. And she was robbed of her dream. She was robbed of her means of earning a living. The children and families in New Orleans were robbed of choice and of access to care. And it's all under this misguided, thoroughly economically debunked certificate of need scheme. We also see harms in the transportation industry. We saw Raleigh Bruner in Kentucky who wanted to start a moving business. In fact, he did start a moving business. He had one truck straight out of college and started helping people move, and he was swiftly shut down after his competitors ratted him out because he lacked a certificate of need. Raleigh went to court, and we actually won his case challenging it under the Constitution. And because of that, Raleigh has been able to expand his business. He now has dozens of trucks in multiple states, and he helps other entrepreneurs start businesses. You see how just giving people the ability to start with one truck can lead to a vast amount of economic opportunity and help to employ hundreds in the process. So what's the legal theory behind challenging certificate of need in court? Well, there are a few. One is that when the state enacts a certificate of need scheme, it is depriving people of their constitutional right to earn a living without any good reason. There's no evidence that these laws protect the public in any way. It is an arbitrary exercise of power. It's basically a handout to the incumbent businesses, and for that reason, it violates the Due Process Clause of the 14th Amendment, which states that nobody should be deprived of liberty without due process, which means without a rational reason. Very often these laws will also violate the Commerce Clause because they discriminate against out-of-state participants. That is, very often we see that these laws not only create cartels, they create cartels that favor in-state applicants to the detriment of out-of-state applicants. And for that reason, they also violate the Dormant Commerce Clause. In the absence of competition, there is no incentive to provide a better service. There's no incentive to reduce one's prices or to innovate. You're essentially holding consumers captive to your service, which means you don't have to lift a finger. You don't have to do anything, and consumers will still come to you. In a competitive market, you have to stay on top of your game as an entrepreneur in order to stay in business. In a competitive market, consumers and not politicians decide who wins and who loses. And ultimately, that benefits us all because we're the consumers and only we know what's good for us. People in power cannot possibly predict what's in the best interest of every individual. It's only the individuals themselves who decide by frequenting a business over a different business who can really tell us through the market who should stay in business and who shouldn't. If you think you need more videos like this, like, subscribe, ring the bell, or show us some comments in the comments section.